Alrighty, the probate process. This is what the client goes through to get through the actual probate process. Alrighty. It's really important to understand what your client is going through as you're helping them navigate through the probate process of selling real estate. It's more than just real estate that they're going through, it's a process. So let's go ahead and get started. Alrighty, so the 10-step probate process explained. Step 1, file petition and submit death certificate and will. To start the probate court process, a potential personal representative and or administrator must file a petition for the decedent and submit the death certificate and will if applicable. Remember, if there is no will, the estate must be filed intestate, which will become a longer process if there was a will, which is testate. Remember, when we went over our definitions, we talked about how when you have a will, the person already appoints who the PR is going to be. They already have all of their affairs and their plans set for their passing. But when they don't have a will, it becomes a longer process. All right, step 2, the courts to validate the will. If there is a will, the courts will authenticate and validate the will. If you are wondering how the state validates the will, check with your local register of wills. So typically, when a person passes away, the will be filed with the probate court, the register of wills, right? And typically, whoever's filing the will have sometimes between 30 to 90 days to file it after the person has passed. Again, each state, each local jurisdiction is different. Step 3, the courts to appoint the personal representative or administrator. The next step is for a judge to approve someone as the personal representative / administrator. If there is a will, the judge will appoint the person stated in the will. If there is no will, the judge will likely appoint next to kin and or typically the person who filed the petition have the estate open, right? So typically the person that's next to kin or the person who was closest to the decedent will file the petition if that person doesn't have a will. All right, step 4 is to file a publication. After the personal rep is appointed, he or she is now responsible for notifying creditors and debtors of the estate. The PR must file a public notice in a local newspaper or publication to alert all creditors of the decedent's estate, as well as heirs. So the PR is to put that publication out there because it also notifies potential heirs as well. The creditors then have a specified time frame to submit any claims against the estate. If the creditors do not respond within that time frame, they cannot collect on those claims. All right. It is important to check your state's and county time frame limit. The estate publication time frame varies per jurisdiction. In the DC area, like our time frame is typically 6 months, right? In DC, it's 6 months. A publication is filed. All of the creditors are now on notice. So within that 6-month time frame, if a creditor does not come forth, they cannot collect on those claims. So typically when you get into this process with the seller, right, or the PR, whoever's handling the estate, they may or may not be ready to sell because they want to wait until that time period is up so that they can know, what creditors they're going to pay or what creditor they're not going to pay. A creditor just can't come out the blue after 6 months and say, hey, I have a claim against the estate. They have to do it within that specified time frame, right? Step 5 is post a bond. A bond is kind of an optional thing. Typically, in some cases, the judge may require that the personal representative or administrator file a surety bond for the estate. This bond guarantees that the personal representative / administrator will fulfill all obligations set forth by the law, typically pertaining to money and other valuables to the estate. It's really important that you understand what a bond is. A bond is just pretty much making sure or giving insurance to the courts that whoever that personal representative or administrator is will carry out that estate in good faith. Why? Because they have so much control over someone's assets, money, real estate. And sometimes a judge wants to they want surety. They want to make sure that that person is really going to handle that estate in good faith, right? It's in most cases, I haven't seen a lot of bonds, but I've seen them in a few cases. And some of those cases were a bit complicated, so some of my clients had to get bonds. All right, step 6 is appraisal of all assets and property. The PR is now responsible for having all the real property and personal valuables appraised for the estate. The PR will typically hire a third-party appraiser to assess the value. However, if all parties and heirs of the estate agree on the value of the assets, then an appraiser is not needed. In that case, the PR will get a written agreement from everyone involved on the value of the assets. It's really important. This is a really important phase of the probate process, because the PR, okay, the PR has to make sure they are representing the best interest of the estate, okay? What the reason why I say this is because it's money on the line. So if you have, just say, 5 heirs lined up to get a certain amount of money, and let's just say the PR undervalues an asset, that means that those heirs that are lined up, they're not going to get as much money as they may have expected. So this is why it's important that the PR gets a third-party appraisal so they can kind of take their own self out of it. Because what can happen is that the heirs can say, well, how did you come up with that value? And if the PR isn't, an expert in said field, then it could become ugly, pretty much. So if all parties of the estate agree on the value of the assets and they all sign, right, then you don't need an appraiser. And let's just say that parties can't come to terms with the value of whatever the asset is, then a third-party appraisal is needed, and it's best because it's going to protect the personal representative as well. All right, so step 7 is to pretty much pay debts. The PR will either pay the debts with his or her own personal funds or funds in the actual estate. It is important to note that the PR is now fully responsible for the deceased's debts. This is where the role of the PR becomes very overwhelming, because most times the estate does not have enough funds to cover the debts of the decedent. Now the estate has to start selling off assets. This is the part of the process where you see people wanting to sell real estate. A lot of estate sales that I go through, some of the family actually wants to keep the property, but the problem is, since the person died without a will, this means that some of these heirs may have to become your business partners, and everybody doesn't see things the same. So if everybody is not on the same page, it's hard to keep an asset, right? Or it's hard to, continue on some type of legacy if we can't all agree. So what happens is the PR wants to keep the asset. They want to sell it, right? Some other heirs may not want to sell it, but what happens is they have to do what's in the best interest of the estate. So you can't hold a property if you're not making money, right? It's all about money at the end of the day. If you have some heirs who want to get paid and some heirs who want to hold, the judge will end up coming in and making the decision. So this is the part of the process where it's really, really important to understand what your PR is going through. They're not only going through the real estate, but the person that passed may have diamonds, jewelry, valuable purses and things of such, cars, all types of things. And some of these things are financed, right? So if the PR, right, doesn't have that money to pay for these debts, then it has to get paid some way. And a lot of times what happens is they end up selling the biggest asset, which is typically real estate. All righty. So step 8 is to solidify the distribution of all assets to parties. So the next to last step is for the PR to solidify the distribution of the assets amongst the heirs and other parties in the estate. For example, items such as jewelry, clothing, real estate, electronics, money, of course, and other valuables included in the estate. The PR may or may not distribute the assets at this point. Every case is different. It should be handled really delicately, all right? Yet it's very important to know who's going to get what. This is important for bookkeeping. This is important for just making sure that the PR did their job properly. So once the PR knows who's getting what, it makes their life easier. Again, what I tell my clients is, if you don't have an attorney, I could refer you to an attorney. It's important that the PR have an attorney so they can make sure they cover all bases. This is really important because you don't want any problems in the future with heirs saying they didn't get something when they were entitled to it, it could become really ugly. So it's really, really important for the PR to know how to distribute the assets, right? And if the person didn't have a will, they really want to get an attorney, because then they have to follow the state guidelines in distributing the assets and valuables. But if, of course, if the person had a will, then it will already be written out of who gets what. Like, that's why I said earlier, having a will makes things much easier. All right. So step 9 is the review of the estate. After assets are distributed and other real estate is either sold or kept in the family, it is typical for the PR to make sure all records, banking, and bookkeeping is done with great care so that the estate can be closed out properly. Again, like I said, the PR has a really big responsibility. They are responsible for distributing assets, distributing money, and an heir can always come back and say that they didn't get something or something wasn't done properly. So this is the reason why this part of the process is important, because the banking, the bookkeeping have to be done with great care, because the PR can still be held liable. Although the estate may be closed, someone could still come back and make a claim that something wasn't done right. So this is important that you know what the PR is going through, because they have a really big responsibility. And the last step in the probate process is to close the estate. The last step, the PR must file a petition to the courts to close the estate, sometimes providing a closing statement or documents to the judge. Closing an estate means that work of administering the estate is done. This situation is reached only after the estate is properly inventoried, taxes are paid, all debts and other obligations are satisfied, and the remaining assets have been distributed via probate or other methods.